I think we do have an expert now joining us, Tonya Phelan. Is that correct, Eric? Yeah, she's popping up right there. Tonya, thank you so much for joining us again.
Good morning.
So we wanted to just first get your initial reaction of the end of day 3. What was going through your head, especially with that last testimony with Captain Cyber?
Well, it was interesting because I've heard, as you all have been discussing the case this morning, I've heard the word explosive used a few times, and I noticed that things were getting a little tense at the end of Prosecutor Becker's cross-examination of the captain. But I want to circle back to something you were talking about, and that is the first officers that were called by the defense were the responding officers. And this is a little bit of a twist in a criminal case because usually in a criminal case, the prosecutor calls the responding officers to set the stage, right, for what actually happened on the day in question. And the fact that they weren't called by the prosecution and instead were called by the defense is really an interesting pivot, if you will. But I think what the defense was trying to establish with those responding officers is a couple of things. You'll remember that they said they were short-staffed that day. And there is some question about the response time for officers to actually get to the scene. That is something that's going to be in the back of Christopher Schurr's mind as this is all unfolding, right? And they also testified to his physical state when they arrived at the scene regarding that he was exhausted, that he was out of breath. And that's going to play into the elements of self-defense that the defense is going to put forth during this case.
Well, Tonya, you make such a great point there with police officers responding, police officers typically being called on behalf of the prosecution. Do you think this has an impact on the jury seeing which side these officers are speaking on behalf of?
You know, it might cross their mind, gee, why didn't the prosecutor call the responding officers? But it might not. I think most jurors, in my experience, really try hard to pay attention and to listen to the witnesses as they're testifying and don't necessarily get caught up in which side called them. Now, sometimes they do, if that's human nature. But I don't know how much of an impact that will have as much as the words they articulated, right? The physical state they observed Christopher Schurr in when they responded to the scene. And again, solidifying and confirming that GRPD was short-staffed that morning. And so that is also in the back of Schurr's mind, I anticipate, waiting for people to arrive to help him out with this situation that has clearly not gone according to plan.
So I want to ask you about some of the testimony that we heard yesterday. Of course, we heard from Captain Cyver. We also heard from Nicholas Bloomfield, which would have been the prosecution's last witness, kind of giving conflicting testimonies there. And I think that's one of the main bones of contention from yesterday's court session. I want to get your take on that. Does that help or hurt things here for the defense or prosecution? And it's a two-parter for you. If you're a jury member, how are you wrestling with that?
All right, so the first part of that is the experts are testifying as to the theory of the case from the attorney that called them, right? So the prosecutor called 3 expert witnesses who testified as to very specific things, right? The generally accepted practices across the nation for tactics, right, and use of force. The defense is bringing in the training officer, who is an expert, right, in training police officers. He's talking about the day-to-day, boots-on-the-ground way that we train officers to handle particular situations. And so while there are some differences, of course, in their testimonies, there are some things that overlap, right, regarding how much force is reasonable, how much force is unreasonable, and the way officers are trained to react in the time. So, of course, how Christopher Schurr responded that day should line up with the way he was specifically trained by his department. And I think that's what the defense is trying to establish.
Now, I want to ask about Captain Cyver being on the stand yesterday. He was on the stand for a very long time, but the prosecution only got a couple minutes before they had to wrap for the day with their questioning, and they had to restart today. He's already taken the stand. is there any effect that's lost because you saw Becker really kind of getting heated with his questioning? Does he lose steam because he had to start all over again today? And also, does that lose the effect on the jurors? I'm sure they were getting worked up as Becker was talking. Now they have to start all over again today.
Well, that's a really great question. And as a lawyer, I always hated that when my cross-examination got interrupted by lunch break or the end of the day, because you do, as the lawyer asking the questions, you do lose a little bit of steam. And so you have to work over the lunch hour or the evening to kind of keep that momentum going and get ready to come back and do it. So that observation on your part is really well taken. I don't know what effect that's going to have on the jury. Several of us were talking after the trial yesterday, and we're going back and forth on the way Prosecutor Becker almost seemed to be attacking the captain. And I don't know that that will necessarily set well with the jury, because I don't think the captain is trying to be one-sided or the other. I think he's coming in and he's telling, here's my expertise, here's how I train, here's how Schurr was trained, and telling it like it is. So it will be interesting to see how the jury reacts to the manner in which Prosecutor Becker is cross-examining the captain.
Well, I want to ask about that because we heard Hamilton actually object and saying he's being argumentative. Now, I don't think she was saying his tone was argumentative, rather his questioning was argumentative. But again, can a lawyer say, hey, look, he's attacking my witness, he needs to step back a little bit, or is that like off limits for lawyers?
There is an objection that lawyers commonly make called argumentative. Normally on cross-examination, we are allowed to ask very direct, closed-ended questions to sort of control where the testimony is going. It is considered a very assertive form of questioning, but you can cross the line into being argumentative or bombastic with the witness, and that is objectionable. I think one of the things that Prosecutor Becker was objecting to, as I recall, was the way the questions were being asked of the captain, as to how the prosecutor's expert witnesses had testified. And he was objecting to that, saying that that was improper. So the prosecutor's objection was really trying to keep the defense focused on what the captain's testimony was, not necessarily the captain attacking the prosecution experts.
Just in talking to community members, checking out some of the comments on social media, some have been critical of Prosecutor Chris Becker in how quickly, he went through his case and the prosecution rested. What is your professional opinion on that? Is that unusual? What's your response to some people thinking that was way too quick? He didn't even call anyone from GRPD. He had these witnesses who were in question. What are your thoughts?
It would be really interesting to talk to Prosecutor Becker after this trial, if he would be willing to share what his strategy was. I have some ideas what his strategy might have been for not calling GRPD officers, but I don't want to speculate about that. But as far as the length of his case in chief, I don't think we can really surmise anything from that. He called the eyewitnesses, right, and spent time with them, and they set the scene very well. And from there, he turned to his experts. And I think we have to put that in perspective of the circumstances of this case. In many ways, it's not a complicated factual case. There's no dispute that Christopher Schurr caused Mr. Lyoya's death. There's no dispute as to the gunshot to Mr. Lyoya's head causing his death. None of that's in dispute. What's in dispute is whether it was justified. So from that standpoint, when you look at the bulk of the prosecutor's case, all of the time was spent on those three expert witnesses, right? That's where the majority of time was spent, because that's the major issue he has to prove. So that makes a lot of sense to me. And I don't think the public should be concerned that somehow he didn't put forth everything he needed to try to convince the jury beyond a reasonable doubt that Mr. Schurr was guilty.
Now, something you just mentioned there, we have to prove that he was justified in his actions there, whether he felt threatened in this situation to use that deadly force there. Something that's came up time and time again has been that taser, and you see that in a lot of the testimony that we've heard. What's your take on the taser situation there, and how have the defense and prosecution used that to their advantage so far?
Yeah, great question. So first, if I said the prosecutor had to prove it was justified, I misspoke. The prosecutor has to prove that it was not justified. So that's the main thing he was trying to get at with those witnesses.
Right. I'm sorry. I meant the defense in that,
Yeah, yes.
in my question.
Okay. So regarding the taser, it is a big issue in this case because that is the weapon that was used initially in this case. And that's the weapon that Mr. Lioya was trying to either bat away from him or grab it, depending on your point of view. And so in the context of the self-defense and the elements of self-defense, right? Let me just step over to this other side for just a second and say, for self-defense, it has to be established, right, that Mr. Schurr was in fear of imminent death or great bodily harm, and that his reaction was objectively reasonable, both in the amount of force he used, right, in response to what he feared. And so the taser comes into question as to whether or not it was still a deadly weapon after it had been fired twice or activated twice, and what risks it still posed to the officer even after those 2 cartridges had been expelled from the taser. So it makes a lot of sense to me that both sides are really focusing in on the state of the taser during the event, after the cartridges had been expelled, and in the final seconds of the encounter.
And I actually want to follow up with that question. Like both you and Tanner have talked about, the crux of this was this shooting justified? But we've heard a lot of things, the taser, self-defense. Do you think the prosecution and defense has really stayed in line with that, or have they skewed off just a little bit? Because I can imagine as a juror, if I'm being told that something has to be justified, and I'm hearing a lot about a taser, a lot about policies, a lot about self-defense, I might get a little lost. From your perspective, have they really stayed in line with both of their arguments?
I think they're trying to. I think they're both trying to. And I said earlier in the trial, with experienced, talented trial lawyers like we have on both sides, they are very focused in putting their case into evidence, right? They're very organized, they're very succinct with their questionings. We haven't seen them rambling around like they don't really know what they're doing. So they have been very, very focused on the specific things they need to ask and the questions they need answered from the witnesses to get their theory in front of the jury. So I think they're doing what they need to do. And one of the things that I think is really important, there've been a lot of studies done on jurors' attention during a trial, and depending on what study you read, they say that jurors, their attention span is in about 30 to 40-second blocks of time. And so as lawyers, we know that, and we know that we have to ask our questions in a way that keeps the jury engaged. But the other point that I want to make about juror attention, especially in cases like this where a lot of it comes down to the battle of the experts, is the note taking. And there's a lot of different thoughts on whether jurors should be allowed to take notes. Some people are of the opinion that no, we shouldn't allow jurors to take notes because when they're taking notes, they're not paying attention in real time, right? They're writing down something that has already been said and they might miss something in real time. And there are others who think, no, note taking is a good thing because, different people are going to write down different things as it appears important to them. And when they go back to deliberate, they're going to talk about that. So I say all of that to say, I think the jurors are taking notes from what I've been told. We know that they're asking questions, so that's a good sign that they're paying attention. And I'm hoping that they're getting the various points from each side of the case that they think are important so that they can deliberate those when they go back to the jury.
And staying on the jurors, Tonya, that was such a big part as things were getting started. We know that they had a larger jury pool than usual, selecting from some 200 people. But many were also really kind of questioning that process, thinking, no way they're finding 12 to 14 people in the Grand Rapids area who haven't already been biased by just how much this story has been in the news and media and social media. So what can you say to people who are watching about this process and the 12 to 14 people chosen to make this decision?
Yeah, a couple of things I'd like to say about that is, yes, there in the Grand Rapids, West Michigan community, we have lived with this case since it happened over 3 years ago, right? And when you're getting ready to pick a jury, and there has been a lot of pretrial publicity, the judge is obviously going to be concerned about picking a fair and impartial jury. So that's why we saw such a large number of potential jurors called in, just in case they went through a lot who had already formed an opinion. And that leads me to the second point. Just because someone may have heard about the trial or seen the billboards that were up or listened to news reports, that won't exclude them from being a juror. What will exclude them from being a juror is if they have formed an opinion of guilt or innocence without ever hearing any evidence in the trial. And those are the individuals who are excluded. So to prevent anybody who may have formed an opinion during the jury selection process, you'll remember that there were many individuals who were questioned in the judge's chambers if they had had any exposure about the case and had formed any opinions. They were questioned away from the rest of the jurors so that we didn't take the chance that their answers would infect, if you will, the rest of the jury. So that was handled textbook, classic, well done by the judge.
I just want to put you in the courtroom for just a second to kind of get your thoughts on what you feel day 4 is going to hold. As we are, again, just want to reiterate, starting with another round of testimony from Captain Siver from GRPD. And of course, we might hear more defensive witnesses today. What is your take on what we should expect to see today?
Yeah, it'd be interesting to see if we have any more GRPD officers take the stand who were either responding officers or involved in the investigation. I know eventually it was turned over to state police. So that will be interesting. It will be interesting if they call Mr. McFarland back and how they will use that given what happened during his testimony yesterday. And of course, the big question we're all waiting to see is whether or not Christopher Schurr will take the stand in his own defense.
And our last question for you is about those people who are watching. Obviously, there are people who are supporting both sides who may be getting riled up for what they're seeing. What would you tell people who are watching this case about either making an opinion or just preparing for how this trial could go?
You know, what I would say is, if we go back after this happened, there was quite a lengthy period of time before a decision to prosecute was made. And that tells the public that Mr. Becker put a lot of care and concern and investigation into whether or not to charge Officer Schurr, then Officer Schurr. And the reason it has taken so long to get to trial is because there have been a lot of legal significant issues that needed to be addressed, and that's gone up and down Court of Appeals decisions. And so what we're seeing is due process play out, right? This is a trial. A jury of Mr. Schurr's peers will decide whether the prosecutor has proved his case beyond a reasonable doubt. And so on both sides, this is a tragedy for both families here, no matter how you look at it. But the justice system appears to be doing what it's supposed to do. And regardless of the outcome, we should at least take comfort in the idea that the legal system appears to be working the way that it should.
I think that's really good sentiments for people who are watching this, that the justice system is doing what it's supposed to be doing. Tonya, thank you so much for speaking with us this morning. I know we will be talking to you a lot more as this trial continues.
Thank you.